Good morning to all of you. Andarki Shubhodayam. Welcome to Legal Matters by Sai Babu Sankar. This is another contempt case. A very series of complaints, series of contemptuous actions by an advocate, which led ultimately to his arrest and 5 lakhs cost, 5 lakhs fine by Gujarat High Court. This is a sumoto case, sumoto versus Devesh Bhatt and another, contempt case number 5207 by 2011. On 23/7/2025, Gujarat High Court, Justice A.S. Sufia and R.T. Vachinani, A.S. Sufia and R.T. Vachinani, they have found the advocate Devesh Bhatt guilty of the contempt of the court under section 12 of the Contempt of the Courts Act 1971 for levelling false and scandalous allegations. False and scandalous. False means not true. Scandalous, which create unnecessary sensation. Allegations against the judges of the High Court and also judicial officers, as well as the state, the so-called SCDRC, State Consumer Disputes Registry, SCDRC. So ultimately, they have awarded him 3 months jail and 1 lakh or 5 lakhs. I think 1 lakh fine. In the purport of 5 lakhs, 1 lakh fine he has to pay. But of course, he did not attend the court, therefore arrest warrant was issued against him. ఎందుకు వచ్చింది అనేది కూడా మనం తెలుసుకోవాలి, ముఖ్యమైనది. ఎందుకంటే యాజ్ లాయర్స్ యూ హ్యావ్ టు నో, రైట్? సో Devesh is practicing in Gujarat, both in the High Court and also the Sessions Courts. కొంతమంది హైకోర్టులో చేసేవాళ్ళు సెషన్స్ కోర్టులో కూడా వెళ్తుంటారు. పర్టికులర్లీ అహ్మదాబాద్ అలాంటి చోట 2 చోట్ల చేసుకోవచ్చు, రైట్? A sumoto case of contempt was registered against him in the year 2011. That was dragged up to 2025, 14 years. In this meantime, in this interregnum period, ample opportunities were given to him. Ample opportunities were offered to him, but he did not have any remorse. He did not tender any apology. Moreover, he has continued the so-called contemptuous activities. So, by his acts, by his conduct, the dignity and majesty of the court has been obliterated. You have to maintain the dignity and majesty or the decorum of the court. So therefore, actually, he did not spare another person, amicus curiae. He filed a prejudicial notice, he filed a criminal complaint against an amicus curiae. He filed cases against Honorable High Court judges and issued public statements, and also he has issued public notices to the judges straight away and also in the newspapers, and he has named the judges and including the Chief Justice. All these amount to definitely administration or interference in the administration of justice leading to contempt. హైకోర్టు జడ్జిల మీద, చీఫ్ జస్టిస్ హైకోర్టు మీద నోటీసులు ఇవ్వటం, పేపర్లో నోటీస్ వేయించటం లేదా నోటీస్ పంపించటం, ప్రెస్ స్టేట్మెంట్స్ ఇచ్చేయడం. అలాగే ఎమికస్ క్యూరీని కూడా ఆయన మీద కూడా క్రిమినల్ కేసు పెట్టాడు మహానుభావుడు. ఎనీవే, సో 1 or 2 incidents we are going to cite. In the year 2010, he sent a notice to a sitting judge to answer a particular matter in 21 days. ఈయన టైం ఫిక్స్ చేశాడు, in 21 days. Failing which, suitable action will follow according to law. సహజంగా మనం నోటీసులో రాస్తాం కదా, failing which action according to law will be initiated. We will be constrained to take action అన్నట్టుగా జడ్జి గారు కూడా ఇచ్చేసారు, టైం ఫ్రేమ్ పెట్టి 21 days. Right? Then he has issued a notice to the presiding officer of the SCDRC, State Consumer Disputes. Of course, presiding officer is a retired judge. Then 2006, he has given a public notice in a newspaper leveling allegations of corruption and illegal gratification in a particular high court. So, itla chustunte, actually the documents on record, they suggest that he has not only indulged in a boisterous behavior, ఏది పడితే అది మాట్లాడు నోటి దోలు అంటారే, ఇది కాకుండా systematic campaign, systematic vilification with the ill motive to demean and lower the majesty of the court. అందుకనే when we are discussing the professional ethics, particularly rule number 1, I told you very clearly in simple words, have a respectful attitude toward the court. కోర్టు మీద మంచి గౌరవ భావం కలిగి ఉండండి, బికాస్ యు ఆర్ ఆల్సో ఎ మెంబర్ ఆఫ్ ది బార్. అండ్ హూ ఈజ్ ద జడ్జ్? హీ ఈజ్ ఆల్సో ఎన్ అడ్వకేట్ హూ ప్రాక్టీస్ ఆర్ హూ ఈజ్ ఎలివేటెడ్ టు ద పోస్ట్ ఆఫ్ ఎ జడ్జ్. మీకు మీరే గౌరవం ఇవ్వకపోతే బయట వాళ్ళు మీకు ఎలా గౌరవం ఇస్తారని మీకు చెప్పడం కూడా జరిగింది. దట్ మీన్స్ హ్యావ్ ఎ రెస్పెక్ట్ఫుల్ యాటిట్యూడ్ టువర్డ్ ద కోర్ట్. అది లేకుండా నో డౌట్ నోబడి, ప్రతి జడ్జి గారి మీద ప్రతి లాయర్ గారికి మంచి అభిప్రాయం ఉండదు, తృప్తి ఉండదు, మన కేసులు కొన్ని కొట్టేస్తారు. అలాంటప్పుడు యూ హ్యావ్ గాట్ ఎ ఛాన్స్ ఆఫ్ గోయింగ్ ఫర్ ద సో కాల్డ్ అపీల్, బట్ యూ షుడ్ నాట్ కర్స్ ద జుడిషియరీ. యూ షుడ్ నాట్ adversely comment on the judiciary. You can comment on the judgment, but not on the judicial officer. This what we have told you in the beginning itself. Anyway, the documents on record suggest that he has systematically, with an ill motive and with intent to demean and lower the majesty of the court, did all these acts, like sending petitions, sending notices, issuing statements, going to the press, all these things. Right. So, now the advocate on behalf of, lastly, he got appointed an advocate. Advocate Mamulagane Millard, the case has been going on for the past 14 years or 15 years, and he has become bold. His health condition is deteriorating, so it is a serious issue. Health condition is also serious ayindi kabatti lenient view may be shown against him. Previously also, when the bench offered or asking him to tender apology, he obliges, but he will not tender apology. Talkayaptadu velipotadu. He did not. So gatanlo kuda they have given him ample opportunities, like you get appointed an advocate. He did not choose to appoint an advocate to represent him. It is nothing but case of blatant disregard for the law also. So kabatti we have to curb this nuisance with an iron hand. Normal ga అందుకే మీ సెక్షన్ 12 of the Contempt of the Courts Act చెప్పినప్పుడు 6 నెలలు ఏంటయ్యా అని మీరు అనుకోకండి, ఎందుకంటే we are all educated people. So the nuisance should be curbed with an iron hand. ఎందుకు? To uphold the majesty of law. So therefore arrest him, execute the warrant. We are giving an arrest warrant against him. Execute it and put him to the, bring him to the jail. And already 81 period days have been completed. No mercy will be shown, no set off for these 81 days also. He has to languish in the jail for 3 months and he has to pay 1 lakh fine. Very serious contempt case, so be careful, read the case law and enrich your legal. Thank you.